Thanks, Jimmy. Do we need to let people from the lobby in?
Yep, I am going to let everyone in right now, so people should be here and ready to go within moments.
Thank you. Hey, everyone. We're just giving it a moment for everyone to join. Oh, it appears there's been a problem.
Shannon, this is
Yeah.
Marcy. Apparently the invite is a one ID user and you had to go register so that you could get in. At least that's what I found. I don't know if others found the same thing.
I am sending that. I thought I sent everything to everyone, but I'll try again here.
It was in the body of what you sent to register. I just don't know. Everybody, like myself, looked in to see what I actually needed to do. I just thought it was accept and join kind of thing.
Okay, well, since we have people on, I want to be sensitive to everyone's time. So we're going to start. I'm going to introduce our speaker today, and then hopefully others will get the chance to join. We are here with Michael Farrell. He is the supervising staff attorney for the Washington Medical Commission. He has served as an attorney for the commission for 33 years, assisting the commission in the licensing and disciplining of physicians and physician assistants, developing legislation, rules, policy, guidelines, and performance measures, and educating the profession and the public on medical regulation. Prior to working for the commission, Michael was an attorney in private practice in Seattle. He holds a JD from Marquette University Law School and a BBA in Economics and Management Science from Gonzaga. Thank you, Michael, for joining us today.
Happy to be here.
And good afternoon, everyone. Welcome to Mandatory Reporting Requirements for Physicians. My name is Jimmy. I'm going to be helping out today and just going through a few housekeeping items before turning this presentation over to Mr. Farrell. So housekeeping item number one, this webinar is approved for CME credit. Feel free to ask questions via chat during the presentation. But if you'd like, you can also wait till the end where there'll be some time for Q&A. The slides and an evaluation will be emailed to you at the end of the presentation. Please complete the evaluation before Friday so that we can begin processing CME certificates. And then Mr. Farrell, if you go to the next slide for me real fast. Just a couple of ideas. So 1 hour of Category 1 CME credit. If you are watching this in a group setting, please make sure you register for the webinar and complete the evaluation as an individual to receive the CME credits. Detailed instructions will be provided in the email following this presentation. And then next one, Mr. Farrell. And then just as total transparency, this webinar is not funded by any commercial entity. No one in the process of making this webinar had a relevant financial relationship to disclose. And we are all good to go. So now housekeeping is over. Mr. Farrell, take it away.
Yeah, good afternoon, everyone. I'm Michael Farrell, and I'm the supervising staff attorney for the Medical Commission, and I really thank you for the opportunity to speak with you today. I've been with the commission for some time, as Shannon pointed out, always in the role of an attorney, but I've done a number of things with the commission, developed guidance documents, policies, rules, helped the commission in a lot of ways, but most of my time has been spent on the disciplinary side. I've helped the commission navigate the disciplinary process, moving a case from complaint to the end of the process. And in that, I've learned a lot about mandatory reporting, the mandatory reporting laws. So today, I'm going to be sharing with you what I've learned regarding mandatory reporting. The commission has a number of policies and guidance documents addressing a number of issues, but none of them address mandatory reporting. If they did, I'd be going over that document with you today. But since they don't, I'm going to be talking about my view of mandatory reporting. and telling you what I believe the statutes and the rules say. So I'm going to be providing, I would call a detailed overview. And because the commission has no position on mandatory reporting, all the statements that I make today are my own. They're not the official position of the commission. I cannot provide legal advice, of course. You have your own attorneys that you consult with when you face difficult issues regarding mandatory reporting. In my presentation today, I have summaries of the statutes and rules that I think are important. I didn't put the full text of the statute or rule in any of the slides because if I did, they'd be unreadable and unbearable. I did, however, provide links. So whatever format you have this presentation in, I believe you can just click on the link and you can go to the actual statutes and rules and consult with your attorney. I realize that the presentation title might be a little bit too broad. My focus today is going to be on mandatory reporting by MDs and PAs to the commission. There are a number of reporting obligations that our legislature and the Department of Health have placed on healthcare providers. I'm just going to concentrate on the ones requiring reports to the commission, but I want you to be aware there are other ones out there that I'm not going to cover. Also, this is not, frankly, this is not super scintillating material, but I'm going to go through it as best I can and try to make it as interesting as I can. So I'm going to cover today, I'm going to begin with just a few comments about the medical commission, not everything about the commission, but a few things that I think are important to what we're talking about today. I'm going to give you a detailed overview of the mandatory reporting laws. I'm going to talk about when does a license holder have a legal duty to report another license holder. I'm going to talk about 3 exemptions to that duty that exempts people who otherwise would have a legal duty and exempts them from having to make that report. I'm going to talk about when does the license holder have to self-report, report him or herself. I'm going to tell you where to send the report because it's different depending on the circumstances. I'll tell you what to put in the report, what the law requires. And then toward the end, I'm going to talk about when a hospital or a facility has a duty to report. And I do this for a couple of reasons. And I know you're probably very familiar with a hospital's duty to report or a facility. But I want to point out that there's various laws, both federal law and state law, that apply to this. And they're not always consistent. And as a result, a couple of myths have arisen or a couple misunderstandings that I want to clear up. And then I think that will lead nicely into what does the commission do when they receive a mandatory report, whether it's from an individual physician or from a hospital or facility. So a little bit about the commission. The legislature created the commission back in 1881. Yes, 1881. And if you're familiar with Washington state history, you know that's 8 years prior to statehood. So the president of the United States back then sent a physician from New Jersey out to the territory of Washington and appointed him as the 9th territorial governor of the state of Washington. So that governor was a physician. When he came out, one of his first priorities was for the legislature to create a medical board. So they did so in 1881, as well as a pharmacy board. A lot has changed in the last 143 years, of course. Today we have 21 members, all appointed by the governor, 13 MDs, 2 PAs, and 6 public members. The commission has jurisdiction over MDs and PAs, and I know most of you know that, but this issue keeps coming up. And as of July 1, 2024, the legislature created a new profession, anesthesiologist assistants, under the jurisdiction of the commission. So the commission is beginning the rulemaking process to figure all that out in the beginning. We'll begin probably sometime next year or maybe the year after, issuing licenses for anesthesiology assistants. The commission does not regulate facilities such as hospitals or clinics, although this issue comes up quite a bit. And the last thing I want to say about the commission is that being a creature of statute, we have to follow the statutes which set forth the processes and the basis for discipline. There's a very specific disciplinary process set forth in an act called the Uniform Disciplinary Act, or UDA. And it says there are two bases for discipline. One is unprofessional conduct, and the other is impairment. I'm using impairment as shorthand for the statutory definition, which is an inability to practice with reasonable skill and safety due to a mental or physical condition. So there's a statute defining unprofessional conduct, and that statute has 27 subsections. And if the activity that is complained about or reported about doesn't fit within those 27 subsections, those 27 definitions, or it does not involve impairment, the commission does not have a basis for discipline. So one of those is negligent care. And this will be important later in the presentation. Before I talk about what the standard is for reporting another physician, I want to tell you what the standard was so you can see how it changed, how the legislature changed it. Back in 1986, the legislature passed a statute specific to medical doctors, allopathic MDs, that required them to report when they have personal knowledge that a practicing physician has committed unprofessional conduct or is impaired. Sounds like a reasonable standard. At least I think that's a reasonable standard. And in my research, this is pretty much the standard across the country, but it's not the standard anymore in the state of Washington. In 2006, the legislature repealed this statute because they passed another statute requiring the Department of Health secretary to adopt rules that apply to all healthcare professions, and it significantly narrowed a license holder's duty to report. Now, I meant to mention when I was talking about the commission that the commission is housed within the Washington State Department of Health. The Washington State Department of Health provides services and support for all the healthcare boards and commissions and programs. And there are over 80 licensed healthcare professions in our state. So anesthesiologist assistants will be a new one. And so the Department of Health is an umbrella agency. The Medical Commission has independent decision-making authority. But the reason I mention that is because the department and the legislature have tried to make everything uniform regarding healthcare professions. That is, that an MD should be treated the same way as a psychologist, as a dentist, as a nursing assistant, as a counselor. The process for all of them is the same. And so the rules regarding mandatory reporting are the same for all. They're not just for MDs and PAs, they're for all 80-something professions. So in 2008, the Secretary of the Department of Health, or the Department of Health, adopts new rules. So what do those rules provide, and how's the reporting obligation narrowed? Here we go. The department rules provide that license holders must report another license holder when they have actual knowledge of a conviction, determination, or finding that another license holder has committed unprofessional conduct. So compare that with the standard that was adopted back in 1986, which provided that you have to have personal information of unprofessional conduct. Now, under the statute and the new rule, a license holder has to have actual knowledge of a conviction, determination, or finding. So that's what triggers the legal duty to report. Compare that to the next bullet point. So that's a very high bar. The next bullet point is a low bar. When we're talking about impairment, the duty is triggered with much less. It's triggered when a license holder has information that another license holder may be unable to practice with reasonable skill and safety. So this surprises most people. And what it means hypothetically is that a physician sees with his own eyes unprofessional conduct, the legal duty to report is not triggered. We had a case once where a doctor walked into the exam room in his clinic and caught his colleague having sexual contact with a patient. And the colleague acted like he was examining the patient, but it was clear exactly what he was doing. Under that scenario, under this law, that physician would not have a legal duty to report that. And I know that's surprising. It's appalling to me. I think they'd have an ethical duty or a professional duty, but they don't have a legal duty. And by the way, in that case, reporting wasn't an issue because the case was reported. But I use that as an example of how narrow this is and how it can lead to absurd results. So you may be wondering, what exactly is a conviction, determination, or finding? And luckily, the rules define this. The rules define a conviction as a court having found a person guilty of a gross misdemeanor or a felony. Pretty straightforward. It defines determination or finding as a final decision by an entity required to report. This applies even if no sanction was imposed or the license holder is appealing the decision. So it has to be a final decision. Let's say a hospital is in the middle of the peer review process and they have grave concerns, but they don't have to report this until the decision is final. Now, we do have complaints about from other physicians. The commission receives these mandatory reports all the time and takes all of them seriously. Sometimes we get reports from physicians for other reasons. We had one case where an MD reported a fellow MD. MD1 reported MD2. MD2 then reported MD1. And then MD1 was so offended at the report from MD2, he reported MD2 again. So the commission doesn't really try to get involved in pissing matches between physicians or business disputes, but they do look at exactly what was alleged and see what we can find in an investigation. So here are the exemptions. Even if that narrow duty was triggered or the more generous lower bar for impairment is triggered, the rules provide 3 exemptions. I'm going to go over those 3 for you. The first one is that a license holder who's a member of a professional review organization does not have to report. And there's a couple of caveats with that in the rule. Professional review organization means a peer review committee or a coordinated quality improvement committee or something like that. They're evaluating a physician. They don't have a duty to report. However, the organization's duty is triggered when it makes a determination or finding that a license holder has caused harm to a patient or placed a patient at unreasonable risk of harm, or, that word should be or, it has actual knowledge that a license holder poses an unreasonable risk of harm due to a mental or a physical condition. Second exemption is for license holders who are providing healthcare to the license holder, and the license holder does not pose a clear and present danger to patients. This just means if a doctor is treating a patient and that patient has a healthcare condition and that patient is a licensed healthcare provider, the doctor does not have to turn in his patient, does not have to call the medical board or the Department of Health unless that patient poses a clear and present danger to patients. And the third exemption is that license holders who are part of a voluntary substance abuse program, such as the WPHP, they don't have to report the participants in the program who have some type of impairing health condition. They don't have to report them so long as they don't pose a clear and present danger to patients. So let me make a couple of comments about the WPHP. That's the Washington Physicians Health Program. It's an independent nonprofit program organization that supports the health and well-being of medical professionals. So the commission and the Department of Health contract with the WPHP to provide these services and to monitor physicians who have impairing health conditions. And they have an excellent track record. We have a very good relationship with them. They do a wonderful job. When a physician enters the WPHP to get help with any type of problem, the commission is not notified. Now, I know that there are some states where their PHP notifies the state medical board. That doesn't happen here. The vast majority of MDs and PAs in the WPHP are unknown to the commission. We don't know they're there. And of course, that's by design. And the vast majority complete if they have treatment, they get their treatment, they have their monitoring, they get healthy. The WPHP helps them to become healthy and go on to practice safe medicine. And the commission is completely unaware that any of that occurred. The individuals who run WPHP have the same reporting obligations as any other physician or license holder, but this provides an exemption to them so long as the physician in the program is not a clear and present danger to patients. I should mention that WPHP does report to the commission under two circumstances, and this is by statute, that if somebody's in the program, we don't know about them, they'll send us a letter reporting the physician if the physician fails to comply with the requirements of the program, or if the physician is unable to practice safely within the context of monitoring, and then they don't follow the recommendation by the WPHP to leave practice. And we do get those reports. When a physician enters the WPHP, they have to sign a contract agreeing to this. And this is not imposed by WPHP, it's imposed by statute. So that's a little bit about the WPHP and the exemptions. Do license holders have to self-report? Yes, they do. And you'll notice here that the standard is the same. A license holder has to report him or herself when there's a conviction, determination, or finding that they have committed unprofessional conduct, or they have information about themselves that they're unable to practice with reasonable skill and safety. They have a duty to report. There's a statute that says for physicians in the WPHP or the Voluntary Substance Use Monitoring Program, if they fail to comply, then that triggers a duty to report. Of course, the program has a duty to report, but the law imposes an obligation on the individual physician to report. And then there's an extra law that requires any license holder to report when they've been disqualified from the federal Medicaid or Medicaid program. So you may be wondering, are physicians self-reporting, reporting themselves? Yes, they are. We get these reports, and we appreciate these reports. These reports felt they had an obligation to report without realizing how narrow that obligation is. Nevertheless, we accept these reports, and we're glad to get them. Sometimes we can tell that, not that it matters a whole lot, the intent behind the report, but the report is made because they know that another entity is about to report. So they report under duress, but nevertheless, the report is made and we take a look at it. What to put in the report? So there's a statute and a rule that makes this very specific. It's very straightforward. The name, address, and phone number of the person making the report, the same information for the license holder, but it also requires the case number for any patient whose treatment is the subject of the report. We don't always get this information, but that's okay. As long as we have the report, we can go get the patient names. I'll talk about that in a couple of minutes. It also requires a brief description of the summary of facts involved. Again, we don't always get this, but we can get it. If a court action is involved, then we need to know the details. And then we will happily accept any other information that is provided. where to send the report. There's a difference between reporting unprofessional conduct and impairment. With impairment, you have an option, or a license holder has an option. For unprofessional conduct, the rule says the report shall be made to the Washington State Department of Health. And then it says the Department of Health will forward that report to the appropriate disciplining authority. As a practical matter, we get these reports, some of these reports directly, and that's fine. So that's why I put in the slide, report to the Department of Health or to the disciplining authority. For impairment, however, if there's patient harm, the license holder has to report to the Department of Health or to the commission. But if there's no patient harm, then the report can be made to the WPHP. So if you have information that, let's say, a physician is impaired, your legal duty to report is triggered if you're a license holder, but you can satisfy that legal duty by picking up the phone and calling the WPHP and giving them that information, and your legal obligation is satisfied. Now I'm going to talk about reporting by hospitals and facilities. And as I said before, I'm doing this because there are several different laws at play. I just want to raise your awareness about these different laws, especially on the state level, and clear up a couple misconceptions, or at least I've been told about a couple misunderstandings about how these laws apply. So I'm just going to tell you what I think. The federal law is fairly clear, and I'm sure most of you who are involved in this are familiar with this. And it provides that a hospital or other entity has to report to the National Practitioner Data Bank when there's a restriction of privileges relating to the competence or professional conduct, and that restriction lasts more than 30 days. You also, hospital or healthcare entity, has to report a surrender of privileges or a restriction while the physician is under investigation relating to competence or unprofessional conduct, or in return for not even conducting an investigation. What I want to point out here is that federal law requires the reporting entity, when they report to the data bank, they have to send a copy to the state medical board in which the reporting entity is located. I know from experience this doesn't always happen, or at least in the past it didn't happen. That I had people tell me, oh, I thought a report to the data bank was good because the data bank would then send the report to the commission. Well, that was not true a while ago. Now it's sort of true, and I'll explain that. When a report is made to the data bank, it's done electronically these days. The reporter is told that a report has to be sent to the state medical board, and then they offer to send the report themselves. So you can click a button to have the National Practitioner Data Bank forward your report to the medical commission. So they can do that, but you have to ask for it. Now that's pretty straightforward. Now I'm going to get to the hard part, and that's state law. In state law, there are two statutes and one rule, three different sources that impose obligations upon either a hospital or a facility. The first one is in RCW 7041. That's the collection of statutes applying to hospitals. You're probably familiar with this as well. And it provides a hospital has to report a healthcare practitioner when a healthcare practitioner is restricted, suspended, or limited, or terminated based on a conviction, determination, or finding, there's that language again, of unprofessional conduct or voluntary termination while under investigation. And that report has to be made within 15 days. Well, then we come to the UDA, the Uniform Disciplinary Act, imposes a similar requirement. And it says a license holder or facility must report to the disciplining authority when an employed license holder's privileges are terminated or restricted. Notice there's nothing in there about conviction, determination, finding, or even unprofessional conduct. Finally, the DOH rules impose another obligation, and that is a licensed facility must report when a license holder's services are terminated or restricted because a license holder has harmed or placed at unreasonable risk of harm a patient or poses an unreasonable risk of harm due to a mental or physical condition. You notice all these three are not quite aligned, to put it politely. I can't reconcile them, but I raise this just to raise your awareness that they're out there. I think you'll have to consult with legal counsel to determine which one applies to your particular situation. I do want to point out one thing, though. You'll notice that there's no 30-day requirement in state law as there is in federal law. So I've had somebody say, we don't have to report to the data bank or to the commission for any restriction lasting less than 30 days. And that's not true. The 30-day time period applies to reports to the data bank. It does not apply to reports to the Department of Health or the commission. Notice there's no time period here. There is a requirement to submit that report within 15 days. So the way I read this is as soon as there's a restriction or termination, that triggers a state report. What does the commission do with that report? Whether it's from a licensee or from a hospital. Well, the commission receives about between 1,500 and 1,800 complaints and reports a year and processes these complaints. Most of these are not investigated, but the commission uses the same process for processing complaints and reports, complaints from patients or mandatory reports from other license holders or from other entities required to report to the commission. The process is the same. The commission takes a look at the complaint or the report. They decide whether to investigate, and if they investigate, then they take a look at the completed investigation and they determine, is there evidence of unprofessional conduct or impairment? And if there is, then they have to decide, do we begin the disciplinary process? And in less than 10% of the cases, that's the case. Less than 10% of the complaints result in discipline, or at least the beginning of the process. The commission cannot take action based on a privileging action. So if a hospital terminates a physician's privileges, the commission cannot take action based on that. I mentioned that unprofessional conduct is defined by statute, 27 different definitions. A hospital termination of privileges is not one of them. So that's not a basis. It is a basis for a report to the commission, and that's a basis for an investigation. So what does the commission do when they receive a report like this? Well, there's two statutes that provide that, and this is the third bullet point. When a hospital or licensed facility restricts or terminates a license holder's privileges, the medical commission and the Board of Osteopathic Medicine and Surgery can review and audit records of committee decisions. That is, the commission can take a look at the peer review materials or the coordinated quality improvement materials, the CEQA materials, that otherwise would be off limits to anybody. When there's a restriction or termination, the commission has the right to come in and take a look. Now, how do we do this? Typically, we have the investigator contact the hospital or whoever holds these records and tell them, I want to come in and take a look at them and take notes. And they arrange a date and time for the investigator to visit the facility, sit down and look at the records. That investigator does not copy any records. We don't want the records in our file. Frankly, once in a while, the facility will mail us protected records. We mail them right back. We don't want them in our file. We don't have any right to them. We recognize that. So what does the investigator write down? What does she write down? Well, what is she looking for? She's looking for patient names. Typically, we don't have the patient names in the report. We need the patient names because we need to get the records and conduct an independent review of the care that's being provided. and of the concerns raised by the hospital. So she will get patient names, and she may write down concerns with the care given or whatever the concerns were. It could be behavioral. And then that is the jumping off point for our investigation. She will go back and send a letter to the holder of the records and also likely to the physician and say, please send me a copy of your records. She collects the records. The commission looks at that and performs an independent analysis, and quite often sends those records to an outside expert in the field, same specialty as the physician. And then he or she reviews those records and provides us with an opinion. Now, some of you may wonder why the commission doesn't take action in every privileging action, even when we get the records. That's because our expert could disagree with the concerns of the hospital. That happens. We have to, of course, rely on our experts' review. Another reason or difference between the two systems is that the state Supreme Court raised our burden of proof maybe about 15 years ago, maybe longer, raised it from clear and convincing evidence, raised it from a preponderance of the evidence to clear and convincing evidence. So we have a high standard of proof to prove a case of unprofessional conduct or impairment. And the last bullet point, I'm going to emphasize that even if we get information from you, the information is still protected by statute. We can't provide it to the physician in the discovery process. If we get that far, we cannot do it, and we cannot release it in a public disclosure request. And I'm near the end, but I wanted just a couple odds and ends, and then I'm going to tell you a story. If a person who reports to us under any of these statutes or rules that I talked about is immune from suit, and there's two statutes that cover this. They're both worded a little bit differently, but they're both very clear that anybody who makes a report or even presents evidence against another member of the profession is immune from civil liability. It doesn't mean they can't be sued, but they can't be found civilly liable, and the case would be dismissed. In my experience, they're dismissed fairly quickly. And I think I already mentioned this, but there are other laws out there imposing obligations on providers to report to other entities. I just mentioned a couple of them here. And I'm going to end by answering a question that might be on some of your minds, and that is, when does the commission discipline a physician or PA for failing to report, or how often has the commission taken action against an MD or PA who's failed to comply with the statutes and rules that I just went over? And the answer is rarely. Frankly, I couldn't think of one. I went back in my notes over the years and I couldn't find one. And then somebody pointed out to me one of them, and I remember this case, but I can only think of one. That's probably others, but I can tell you over the years, there has to be something egregious in the case. The commission, at least in my opinion, my point of view, wants to protect the public. They don't have authority to punish, and protection and punishment is sometimes a fuzzy line. But the commission also wants to educate its licensees. And when they fail to report, it's usually an opportunity for education about what the duty is to report, and the person isn't disciplined. I'll tell you about one PA who was disciplined. This PA owned an urgent care clinic, and the PA employed his supervising physician to work at the clinic. The MD was listed as the supervisor in the PA's practice plan. So the PA was both the MD's employer and supervisee. So you can see the potential for a conflict in this type of arrangement. And I should say, there's nothing illegal about this type of arrangement. In fact, the commission has a policy on it pointing out the pitfalls, but just telling people to be aware of the potential conflicts of interest. And this case illustrates this perfectly. The PA reported to the commission sends a report in alleging that the MD was ordering testosterone and human growth hormone and taking these substances for personal use. The MD was also prescribing these substances to patients without doing any physical examinations. And the PA also alleged that the MD was being aggressive and threatening to the PA and to clinic staff. So you might think, well, what's the problem here? Sounds like the PA did the right thing. Well, the PA admitted to the commission that he waited 1 year to file this report, and he was reluctant to file the report because he feared that if he reported the MD, it would result in the closure of his business. The commission was concerned about this 1 year delay, particularly not only the potential impairment that this MD was exhibiting, but also that the MD was engaged in potentially criminal behavior and that the PA was aware of it and didn't report. So this PA was placed on probation for 2 years and required to take an ethics course, and in some type of language promised not to find himself in this situation again. So granted, this case is pretty unusual. It's not the typical case involving an MD failing to report another MD. Again, those typically are not disciplined, but I wanted you to be aware that's one case. So I'm going to conclude with the mission statement. Mission takes its mission very seriously. Statutorily, they're charged with protecting the public. The mission statement says the commission's mission is promoting patient safety and enhancing the integrity of the profession through licensing, discipline, rulemaking, and education. I'm focused today, of course, on the last word, education. I hope you've found this presentation helpful and useful in your work. I find the commission's work fascinating. That's why I've been in it so long. And I thank you today for your interest in the commission.
Thank you, Mr. Farrell. If anyone has any questions, feel free to use the chat, or you can raise your hand and I can unmute you and we can get those questions sorted.
And Jimmy, just so you know, I can't see the chat.
I'll read you the question in case if anyone types in there, but again, feel free to raise your hand. And also you see Mr. Farrell's email here. We're available for follow-ups in case anyone thinks of something later or requires clarification. Feel free to reach out to us. Our website also has a bunch of resources regarding when to file a complaint, how to file a complaint, all in the FAQ section. So I hope you take advantage of that if needed. But yeah, reach out if you have any questions or need further clarification. We're here to help.
Yeah, I'm happy to take any questions via email. It's part of my job.
Okay, so we have a question. It's not directly related, but to this presentation. But you mentioned the board will have oversight of anesthesia assistants soon. When does that go into effect?
Well, it depends on how quickly we can do rulemaking. Somebody told me recently it may not. We have a long, extensive rulemaking process, and there's a lot to figure out. I'm not directly involved in this particular rule, but from experience, it can take up to a year to get through that process. So realistically speaking, I heard that the goal was January of 2026 for the rules to take effect. Now, it could be done sooner, but that's what I heard.
Yeah, chances of it being done sooner than that are slim to none. like Mr. Farrell said, we have to go through a rulemaking. We have to charge these folks. So there's a lot of study and stakeholdering that goes into setting up this profession and then figuring out how to regulate it. So that profession will be under our jurisdiction, but not anytime soon. Well, Mr. Farrell, I don't see any other questions, so you did a great job. Everyone's questions about mandatory reporting have been answered.
Or I suspect they're thinking them through, but thank you very much for your time. Mr. Farrell, we really appreciate it. I think it was really value added.
You're very welcome. And if anybody has issues that happy to be here.
And in a little bit, everyone will receive an email with the slide deck, the evaluation for CME, and a couple other little tidbits of information and resources. That will be coming from my email address, jimmy.bush. So you can reach out to me as well if you have any questions. But yeah, look for that, and please complete the evaluation by Friday so that we can go ahead and get those CME certificates on the way. So if there are no other questions or hands, thank you so much for coming today and participating. It's always nice to have folks involved, and I really appreciate you, Mr. Farrell, for talking with us today.
You all.